appeals. All persons having business before the Honorable Chief Judge and Associate Judges now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and His Honorable Court. This Honorable Court now in session. Please be seated and come to order.
All right, good morning, everyone, and welcome to the District of Columbia Court of Appeals. We have one special sitting this morning. This morning, I'm joined by Judge Corrine Beckwith and Judge Joshua Deal, and I am Chief Judge Blackburn Rigsby, so it's good to see everyone. Our case this morning is in re petition of EE and P.C.T. and I.W. Parties ready to proceed?
May I proceed?
Yes.
May I please to court? Good morning, Your Honor. Your Honor, we are here today on an appeal by my client, who is the father in this case.
Mr. Mayor, I'm sorry, could I ask you to just state your name for the record?
I'm sorry, my name is Madhavan Nair. I represent the biological father, who is the appellant in this case.
All right, and did you want to reserve any time for rebuttal?
Yes, Your Honor, I will like maybe 2 or 3 minutes.
All right, thank you.
Thank you, Your Honor. Your Honor, this court has ruled several times that the father has a fundamental liberty interest in preserving the relationship between parent and child. This fundamental interest gives rise to the legal presumption that the child's best interest will be served by placing the child with his natural parent. Parental fitness is not statutorily defined in this jurisdiction. It refers broadly to the parent's intention and ability over time to provide for a child's well-being and meet the child's needs. The fitness inquiry therefore turns on whether the parent is within a reasonable time and will be able to care for the child in a way that does not endanger the child's welfare. You know, what we have here is here's a father. It is true he doesn't have a house, but he has made an alternative placement for his sister. The court's finding that my client is not unfit to parent the child is wrong. I would respectfully submit the court. There is not sufficient evidence for the court to make a decision that my client is not a fit parent. This is a case where in the record will show that the child, the subject matter of the child, IEW, was not removed from my client's care. The child was removed from the mother's care. My client was not part of the stipulation. There is no adjudication of neglect against my client.
Right, but as the process was going on, there were certain goals that were set for your client along the way. It seemed to be made pretty clear to him that these goals have to be accomplished in order for him to be able to keep his son. And how do you get around the fact that I think an admitted fact that although your client did participate in a lot of some therapy, some parenting courses, but didn't really follow through and finish any of them up?
Respectfully, Your Honor, if I may respond to that, Your Honor. It is true that the issue brought, I think one of the arguments, the government argument is that my client has some mental health issues. We have the court admitted several exhibits and also allowed to have the expert testify in this case. However, that evaluations has been over 3 years old. The adoption petition has never requested an addendum to those reports, and there is no evidence to the fact. In fact, when we had the trial, my client was still suffering from the.
But what do we do with that? I think you argue in your brief that means we give no weight to those reports at all. But wouldn't that just be a question of how much weight we give to them?
That may be, Your Honor. However, the fact of the matter is that there is no nexus between, assuming argument take that he has a mental issues. There is no nexus between his mental health issues and then that would affect anyway that care for the child. Here is a father who has been visiting the child, and the visits has been going very well. According to the record shows that he visited almost 70% of the time, and he brought gifts and toys for the child. And there is the testimony why one of the witnesses was that he is really bonded with the child.
Mr. Nair, can I interject here because the 70% visitation rate and the report that he had bonded with the child and that they had a child appeared to look forward to his visits, I thought was compelling. But the concern I had reviewing the record was a follow-up to what Judge Beckwith was asking about, the mental health issues that were not being addressed despite the opportunity and the connection with mental health professionals, and also anger management. And then the last piece was a stable housing environment. One of the requirements of fitness is whether or not there's evidence that the parent can become fit and address some of the impediments to parenting within a reasonable period of time. And I don't see where that was argued by you below, whether your client, the father, could have become fit and accomplished the remaining things that he had not completed within a reasonable period of time. I guess 27 months had already elapsed where these efforts were being made to reunite him with his son. Did you make an argument that he needed some additional time? And if so, was that a reasonable amount of time for him to complete the other requirements?
If I may respond to that, no, I did not ask for an additional time. I asked the court that there is not sufficient evidence that he is not a fit parent. There is not sufficient to conclude that he's not a fit parent based on the evidence presented in the case. First of all, there is the anger management issue. There is testimony here and there is heat. There is one incident where apparently he was involved some kind of altercation with somebody.
No, I think he does admit that he has some issues with anger management.
But this child was not involved, Your Honor. This child was nowhere present when this incident happened. There is no allegation that he has assaulted or threatened or anyway misbehaved this child. This child was not. He was actually defending another of his child, and that really happened. Then regarding the mental health, there is no allegation that he appeared so many visits, and none of the visits he was under the influence of any illegal drugs. There is no any kind of inappropriate behavior on his part. If that was the case, I can understand, but that is not the case here. This case was brought up against him. There is no allegation of the anger issues. There is no allegations of that. As the case progresses, the government brought these issues that he has some mental health issues. To some extent, he has addressed to those mental health issues. He did participate some of the therapy sessions. But he has some excuse of why he did not go to because this case was going through the COVID period. There were some excuses that why he did not go for all the therapy appointments. I'm not saying anyway condoning my client's action, but when you look at the overall evidence in this case, is there any sufficient evidence to conclude?
What about the housing piece? Because I know that there were efforts with the team from I think it was a peer counselor and the social worker to connect him with resources to help him find a stable housing environment.
But nothing has, again, housing is not a housing mere fact that he doesn't have a house. That is so fact it does not prevent him getting a child. That does not that is not enough for the court to conclude that he is not a fit parent. I mean, poverty is not a reason to take away the child from the parent. Poverty it is true that he made some efforts to what extent did he make full efforts to obtain the housing? That's an issue, but he has made some attempts to get the house, and so again going back to the issue of whether or not is in a Is it a fit parent? Is it unfit? Is based on what we have here today is to based on what was presented at the trial side. There is not enough evidence to conclude that he is not a fit parent. In my opinion, Your Honor, he is still a fit parent to care for the child. He has not abandoned the child. He has maintained relationship with the child. So under those circumstances, I would respectfully ask the court to reverse the decision.
All right, thank you.
Thank you.
Unless there are any further questions, you can reserve the rest of your time for rebuttal. Thank you.
Yes, sir.
Counsel?
May it please the court, Pam Sanchini on behalf of the district.
Good morning.
Good morning. This case began 5 years ago when CFSA removed an infant child from his mother due to neglect. And appellant here makes much of the fact that the child wasn't removed from his custody or that there were no allegations of neglect.
Well, that's true.
But the fact was that at the
And here you have a father who, this record's a little different from some of the records that we see in similar cases, where the father appears to be making some concerted efforts to make the visits, to make a bond with his son, and to go to some of the mental health referrals and some of the anger management referrals. So we have probably a little more than we have in many other cases, where you can see some effort and some sincere desire to be reunited with the child. I guess what is the key here in your view that warrants the
Well, I would respectfully disagree that he made concerted efforts. I think that over the course of 5 years, he attended less than 10 therapy sessions. That's not a huge effort to address your mental health. He attended.
What was his mental health diagnosis exactly? That was a little unclear to me.
It was a little unclear. He reported himself a diagnosis of bipolar disorder when he underwent his mental health evaluation with the Department of Behavioral Health. Both Dr. Toit and Dr. King, who provided expert testimony, also provided a diagnosis of bipolar disorder. And it's true that while he was at New Hope, he was being treated for major depressive disorder with psychotic symptoms. And there was no real explanation as to why the discrepancy between the two diagnoses at that time. But the underlying symptoms that he reported fairly consistently did not change throughout the life of the case. He had serious anger management issues that he himself reported several times, an inability to control himself when he got angry, punching walls, breaking windows, certainly never in front of IEW, but in front of his other child on one occasion. And as Dr. Toit explained, that behavior can be very damaging to a child. Maybe the child's not physically injured in that episode, but they certainly can be psychologically injured. And over the course of 5 years, I would disagree that he did much to address those issues.
Can you tell me, it's interesting to me how we figure out what fitness is, because I feel like if someone is not in the system and they have anger management issues or something like that, their kids aren't necessarily going to be taken away from them. But you know, in this situation, do you think fitness comes down to not jumping through the hoops that the court sets for you? And if that is, if you don't finish the program, you participate in it, you do 70% of your visits, you do some therapy, you do some parenting classes, but you basically, you don't see it through. Is that how we define fitness?
I think SLG takes a pretty good stab at defining fitness about a parent's intention and ability to resolve the issues that brought the child into care. And in this case, it was the father's lack of involvement that resulted in the child coming into care. So even though there weren't neglect findings, he did state that he was unable to provide care for his child at the time of removal.
When he was in jail, right?
No, he was not in jail.
No? Was he All right, my
The
mistake.
magistrate judge says that, but I don't know.
That he was incarcerated for a period of time, which I thought was at the time the child was removed, although he may have been released shortly thereafter.
Yeah, it's at page 12 of the magistrate judge's findings. Mr. Nguyen was incarcerated at the time of IAW's removal. So I'm not sure. We'll clear it up though when we review.
Yeah, I don't recall him being incarcerated, but if he was, it was at the beginning. By the time the court gets to disposition, the father states that he's unable to assume care of the child because he lacks housing. But I also think that SLG points to other factors to consider, and it does involve the inability or unwillingness to make reasonable efforts to correct the behaviors that led to the child's removal, and to provide the child with a safe and stable home, and to meet the child's particular needs. And IW was unable to do any of those things by the time we got to an adoption trial 5 years later.
Well, at what point in time did the father stop making efforts? Because he is making efforts, as indicated. He attended some of the mental health treatments. He attended 70% of the visits. He's trying to juggle a part-time job. He is caring for another child. His housing situation is unstable. As I understand the record, he had some periods of homelessness, but periods of staying with other people. How does that equal unwillingness to care? I mean, it seems to indicate just the opposite, I think.
But it's a willingness to make reasonable efforts. And just on a quick count, he attended 12 therapy sessions over the course of nearly 3 years. That's not a reasonable effort to correct the situation that's resulting in your inability to resume care of the child.
How many would have been reasonable in your view?
It was recommended by both Dr. King and Dr. Toit that he attend weekly sessions. So weekly sessions or somewhere close to weekly sessions.
So he's attending weekly sessions, anger management. How often was he supposed to attend that?
I don't know if there was any specific request in terms of frequency, but when he was attending therapy at New Hope, it was recommended that he participate in a specific anger management class that New Hope also offered, and he never attended that.
Didn't he indicate that some of the missed appointments, I forget whether it was for the visitation or mental health, were due to his work, trying to juggle work or caring for the other child or children that he had?
The record shows that father was co-parenting with the other children, with the children's mother, not that he was providing sole care. And
What's
when
that distinction?
the distinction is that
Did he indicate that some of the missed appointments were a result of his efforts to care for the other children or for work? I know sometimes there was no excuse given in advance, but wasn't that an explanation for some of the missed appointments?
my recollection is his explanation for some of the missed visits was that he was too busy with the other children, not that he was providing care, but he certainly could have brought his children to the visits. It wasn't a reasonable excuse. Your child is in care, you get 1 hour a week. And I think 30% missed visits when you see your child for 1 hour a week is a large amount of time for a young child. In the months leading up to the adoption trial, he had missed 7 visits in 6 months. That's a quarter of his visits. He couldn't even recall at the time of his testimony when he last saw his child. And his missed visits, I think, were critical. You know, he was offered the opportunity to participate in therapy with IEW, and he never did. The child, as a result of being in foster care for years and being placed in 10 different foster homes, was exhibiting behavioral problems and attachment issues and dysregulation problems. And he'd been in therapy for well over a year, and father had not participated in that. He hadn't participated in his education. He didn't really do a lot. In addition to missing 30% of his visits, he didn't take other opportunities to parent his child.
How was, I guess it was unclear in one part of the record to me, how the father was made aware of some of the educational issues with his child. or the special educational issues or needs?
Yeah, I'm not recalling how he was made aware of the educational meetings, but the social worker did testify that as far as the medical appointments that he also did not attend, that he was included on all emails regarding scheduling, that scheduling was done as a team. And he was informed of when the child's appointments were. So there was never any argument made by counsel that he didn't know when he was supposed to be somewhere. Father knew what he was supposed to do, and he didn't make reasonable efforts to accomplish those things.
Can I say, question, what, do you think the ultimate question of fitness is a legal question? I mean, obviously it has factual elements to it, but what does our case law say about that, if anything?
I think it's a factual question. I think that whether the father makes efforts to address the issues, whether he's working on putting himself in a position where he can resume care of the child and resolve the issues that brought the child into care, that reflects his fitness. A number of the factors that the court articulated in SLG and has repeated several times since then are present here. The past neglect of the child, the failure to maintain contact with him at times.
Past neglect, but I thought there was no neglected adjudication specifically related to the father's.
The child was adjudicated neglected, and at the time,
With the mother, at the time he was living with the mother who stipulated, I believe, to the neglect.
it's correct that the mother stipulated to neglect, but the court finds that the child is a neglected child, and that determination, had father been in a position to care for his child and receive his child into care, we would never have been in a position to adjudicate IEW, a neglected child, because the child would have had one parent who could have assumed custody.
But you said it was based on SLG, you look at the past neglect of the father here, and I was just trying to figure out.
The past neglect of
what
the
that
child.
was. Okay.
And when the child came into care, the father was uninvolved. The child's medical needs weren't being met, and the father wasn't doing anything to intervene or protect the child from the neglect of the mother. So in that way, he did.
When he possibly was incarcerated. Based on
Yes.
the magistrate judge's determination. I understand after he was released, perhaps that might have been the case, but what you said, fitness is, you believe, a factual determination, and here the father didn't make reasonable efforts. What equals reasonable efforts? Is it 100% compliance with the plan laid out by Child and Family Services and the team? Is it 70%, which in some places would be passing a grade? Is it 85%? What equals reasonable efforts in your view, or as we weigh the legal and factual issues here?
I think it's dependent on the circumstances. This court has found parents unfit despite stellar participation in DRM, for example, which has a lot of similarities to this case. In that case, the parent was actually participating in services regularly, but the progress hadn't yet come with the mental health issues, despite participation. So it isn't just about participation. In this case, we don't even have that amount of participation. It was a very short-lived time that he attended therapy, each time reporting ongoing mental health issues. In January of 2022, just months before the adoption trial, he's still reporting anger issues, agitation, irritability, trouble sleeping. So given the ongoing symptoms that he's presenting, it required him to do more than just attend 12 therapy sessions over the course of 3 years.
Was he also ordered to take parenting classes? I don't recall seeing that.
He was ordered to take parenting classes from the beginning, from the initial hearing, and he did not do that, despite many opportunities to do so, including the referral to a peer mentor who provides individualized parent education. She meets with the parent. In this case, she met with the parent. I think he completed a handful of sessions and then lost touch with her. She testifies that she kept the case open for 30 days waiting to reconnect with him, but he never contacted her and he never completed the parenting class. He was referred to a parenting class in the community, fell asleep at orientation and never retook the class. And the social worker did talk to him about parenting classes, to learn strategies to deal with IEW's behavior during visits, to help, have consistency in terms of discipline when he's having a meltdown and not indulging him. These were things that were important for him to learn in a parenting class, and he simply didn't participate.
Do we know what, I don't know if this is in the record or not, but what the status of his relationship with his other children is? Does he have parental rights as to his other children?
He does have parental rights as to his other children. I believe he has 4 other children, all of them older than IEW.
Okay, and this also, I think, is not relevant basically because the magistrate judge dropped a footnote saying it's not irrelevant, but I really was wondering, because it comes up so often, what does it mean for CFSA to substantiate an allegation such as the assault allegation in this case?
When CFSA substantiates an allegation, it's because they have found credible evidence to support the allegation that is not against the weight of the evidence. That's how it's phrased in Title IV for substantiation. And in this case, there was substantiation that occurred just a few months before IEW was removed.
I just wanted to circle back to one other thing. Ms. Davies, Doris Davies, who was IW's social worker and therapist, my notes indicate that she testified that he told her due to his part-time job, he could not attend therapy consistently. Were efforts made to try to schedule therapy around a time where he could go so that it didn't interfere with his work? Because it seems to me his ability to retain some type of employment was also important to his ability to parent.
I don't recall evidence about efforts made in that regard. I do think she also testified that he stated that he was attending AA meetings around the time that he was supposed to go to therapy, and there was a change in schedule made to accommodate him so that he could go to therapy before the AA, because he reported he was doing that regularly. So there were some efforts made to accommodate his schedule. Unless the court has questions, the district.
I do have one more question, sorry. When the magistrate judge was going through the various factors and got to the factor involving drug-related activity in the home, is this typical that the judge found that there was no evidence of drug-related activity in the home, so therefore deemed it irrelevant? Wouldn't that be more natural to say there's no evidence of drug activity, so it's in the father's favor?
That would seem like a better approach. I think that in this case, his use of alcohol wasn't a big factor throughout the case. Certainly, it's a positive factor that he's not using alcohol, according to his testimony, and according to the social worker who reported that she never saw him under the influence. But it wasn't what brought the child into care. It wasn't what kept IEW in care for all of those years. So I think maybe for that reason, he might have said that it was not really a factor in the case.
So you mentioned DRM, and I guess I'm pressing on this because we see a lot of cases come to us with a similar issue here about whether the parent is withholding their consent to adoption against the best interest of the child. And we've certainly seen cases with more egregious factors in terms of the behavior of the parent. Which case is this closest to? I guess the facts here are you have a parent who did a lot, didn't do everything, is trying to hold down a job, has custody of his other children who he's trying to keep a relationship with, makes many of the visitations, but not all, misses counseling, a number of counseling sessions, and and other things, you know, it's hard to figure out exactly where on the continuum of other cases that we see we're at here. I know we're not supposed to necessarily compare, you know, how well established the adoptive parents or the parents seeking to adopt the child may be with the circumstances of the birth parent. We're looking at fitness, his fitness only to parent now or in the near future or within a reasonable period of time. And I'm still stuck on the fact that this may be a little closer than some of our other cases.
I think as far as which case, I think it's most similar to, I'm going to stick with DRM. I think in that case, this court found that due to the mother's long-term ongoing unresolved mental health issues, her refusal to admit the neglectful condition of the children,
In DRM, which I am very familiar with.
yes,
The mother had significant mental health issues that played out in how she treated the children who had been in her custody, and including some delusional behavior, if I'm getting the facts of this case right. We don't see that here in terms of the father's mental health, and it certainly wasn't his mental health that led to the children being removed, which I think was a situation in DRM.
in DRM, the children were removed from the mother because the house was uninhabitable.
Which was a part of her mental health ethos, if I recall correctly.
Yes. In that case, we had testimony that the mother's mental health prevented her from putting the needs of the children above her own. Here, the father suffers from whether it's bipolar disorder or major depressive disorder with psychotic features. The testimony that the court received was that the father, due to the manic episodes that he reported during his meeting with Dr. Toit, would be unable to focus on the needs of the child. I think Dr. Toit's testimony, in fact, does a very good job of explaining the nexus between his mental health and the care of the child. But the difference in DRM is that the mother regularly attended therapy. She was compliant, and still this court found that she was unfit. She failed to take medication. IEW has not been taking medication. When he went to New Hope in January of 2022, he said he was not medication compliant. In DRM, the mother canceled several visits over the course of years. I think we can categorize that his visitation track record similarly. He missed several visits over the course of years. She failed to appreciate the children's needs. In that case, it was the children's educational needs and their dietary needs. And here it's his IW's need for stability and permanency and attachment and the behavioral issues that he was displaying as a result of not having a stable home. And DRM still lacked stable housing. The mother did in that case. She, despite the fact that the kids have been removed due to the deplorable conditions of her home, she never allowed the social worker to go in. And here we had the same thing. The social worker tried to assess the father's housing situation. She tried to go visit the home where he said he was living, and he either didn't show up or she wasn't allowed in the home. So for that reason, I think that the facts are comparable to the situation in DRM, despite the difference in diagnosis.
Can I ask for a clarification of something you said in your brief, which is, I think you said that the father is not raising the issue from the trial court involving the fitness of the adoptive parents. And it looks like on page 35 of his brief, he says, you know, something about the court's findings that the adoptive parents are fit and able to provide IEW a proper home and education has not been supported by sufficient evidence. Did you just mean he didn't support an argument, or
We didn't develop the argument?
Okay. I mean, that's, yeah, the way, unless I'm confusing this with another case, which is really, really possible. I thought your statement was just, that's not raised, but I mean, it's not raised, I understand,
Yeah.
but it's sort of raised, but I had one other question, let me see. Yeah, is there evidence, I thought I read somewhere testimony by the adoptive mother, I think, regarding but regarding the father visiting post-adoption. Did I imagine that?
I'm not recalling her
Okay.
testimony on that issue.
Okay, thank you.
There was testimony from, I believe it was the social worker, that during the visits that she observed the father with the child, that the child seemed to look forward to the father's visits, and they seemed to have a good interaction during those visits. Am I correct with that?
I think you're correct. I think she did state that he had a good time at visits, that that the father brought food or toys and they played games, but that she also testified that she felt like he focused too much on playing games, and sometimes to the exclusion of interacting with him. But IAEW doesn't need a friendly playmate once a week for an hour. He needs a parent.
Well, the father only had once a week for an hour to visit.
For his own, by his own making. He didn't, my recollection, he never asked for more visits. And his own sort of lack of compliance with mental health services left the social workers concerned about liberalizing his visits or giving him additional time with him.
Anything else?
We would ask the court to affirm the final adoption decree. Thank
All
you.
right, thank you.
Thank you, Your Honor.
Mr. Mayor?
Your Honor, respectfully, I would disagree with the government's arguments, some of the arguments. Mainly, Your Honor has asked a question whether it is a fitness is a factual or a legal issue. I would submit to the court it's both a combination of both legal and factual issues. When you look at the totality of the evidence, I would submit to the court my client is a fit and proper person to care for this child. Your Honor, here is a situation wherein, as I previously stated, this child was removed from the mother's care, not from my client's care. And for a long period of time, the agency was focusing reunification with the mother, not with the father. Subsequently, later on, when the agency court found out that mother is not coming forward doing the things supposed to do, they changed the goal back to the reunification to father. Then he got a very limited time for about, it is true the child was in the system for about 4 years. But for the most part of the period, 2-3 years, the agency was primarily focusing all the attention or providing all the help the mom needs. So when
Can I ask you a question on that point, Mr. Mayor? The 27 months that I understood was the point that the magistrate judge was looking at, during which the father had an opportunity to make reasonable efforts and fulfill the requirements. Does that 27-month period include the time that the reunification efforts were focused on the mother only?
I'm not quite sure on that issue, whether or not I know, but looking at I have been involved from the early on in this case. I think most of the time, for a long period of time, the agency was focusing on the mother, not providing any assistance or not making any efforts for reunification with the father. With respect to the mental health issues, there has to be there has some kind of connection. There's a alleged my client's mental health issues, and that how it is going to affect this child if it's going to take it. The evaluator, Dr. Troy, in fact, said, well, perhaps in hindsight, we should have gotten an addendum or a recent report, whether or not the father is still suffering from mental health issues. There is no evidence to this. The child, they have not seen the evaluator has not seen the child and my client together. The evaluator only saw so how can we make an effort, assuming arguments like has a mental issue, how would it affect that care for the child? There is no evidence to that. With respect to the visitation, Your Honor, my client has participated, the father has participated most of the appointments. It is not, the evidence, the record is not quite clear as to whether he was informed all the medical or these other appointments. On the other hand, the evidence should show that in fact, the social worker has testified that he has appeared or he has participated in many of the child's medical appointments. And
Now, you said the evidence is not clear that he was informed of some of the appointments related to the child's education or counseling.
that is true. I don't think the agency has informed all the medical appointments, all the other appointments of what is going on with the child. Whatever he was told that the medical appointments, whatever other issues, therapy appointments, he did participate in some of these the appointment. Regarding the visits, Your Honor, it is true that he participated about 70% of the visit. At the one point, there's also testimony to the effect that there was a previous social worker has given him some unsupervised visits. That visits were in very well. Then there was another social worker came on board. That worker did not provide him continued turn. So he did have unsupervised visits and visit very well. You cannot expect, I'm not saying 100% my client is a perfect client. You cannot expect a 100% perfect father. It is true parents make mistake, but the question before the court is whether or not is there enough evidence to conclude that he's a fit parent. In my opinion, based on what we heard, what we presented, there was two TL hearings in the case. The first TL hearings, the magistrate judge did not grant the government's request to change the goal to adoption. Then there was subsequent TL because the agency did not make reasonable efforts to get reunification with the father. So there was subsequent TL hearing, the court changed the goal to back to adoption. So when you look at the totality, he has made some efforts. He has made some effort. So the government's argument that his inability to care for the child, that is not, there is no evidence to that. There is no evidence that he is using any illegal drugs. There is no drug test has been presented court. No evidence to that he has alcohol problem. It is true that he participated some of the parenting classes, but again, going back to the issue of how this case was brought in the system, there was no fine, there is no adjudication of neglect, there is no allegation that my client, the father, has neglected the child. The whole day agency was focused, the child was removed from the mother's care. They were focusing on the mothers for reunification. Later on, another
Was your client, was the father incarcerated at the time that the child was removed from the mother's care?
I don't think, I'm not quite sure whether that he was ever incarcerated. I'm not sure there is no evidence to that my client was. I may be wrong, but I don't see anything. So far, I have not seen evidence that he was incarcerated, and government has not provided any document to show that he was incarcerated.
That was, I thought that was one of the magistrate judge's findings in the record.
It's part of their findings, and I think part of his statement recounted in one of the reports was that in 2017, he was incarcerated in relation to a domestic abuse fight with one of his, I don't remember if it was the mother. I think it was the mother of IEW. So, I mean, that's some evidence of domestic abuse. Granted, it's not against one of his children.
But that there was no such evidence presented at the adoption trial. My client was incarcerated. I don't think there was ever evidence. So again, Your Honor, when you look at the totality of the case, Your Honor, I don't think that there is enough evidence to conclude that my client is not a fit person to. I would submit to the court that he's a fit and proper person to care for.
So this is the psychological evaluation from DBH, and you can find it at page 112 of the joint appendix. He said this is purporting to quote your client. He said that he was in the DC jail due to the domestic violence charge. It describes the domestic violence charge shortly before that. I don't know which way this cuts. I mean, part of the argument could be, well, to the extent any neglect from your client stemmed from incarceration, that's certainly been addressed. But another way of looking at it is, there is a history, it appears, there's evidence of a history of domestic violence. Your client is not taking anger management courses, and during the course of this proceedings gets in another fight, which is not very well fleshed out in the record before us. It sounds like his explanation was that his daughter was getting in a fight with a woman and he intervened. But those are some causes for concern about failure to take anger management courses and failure to address some admitted anger issues that he has, right?
Respectfully, Your Honor, domestic violence issues or anything, this child was not involved in any of those.
Yeah, but when would he have been? Throughout the course of this child's life, he's never been in the custody of your client. Your client was, it sounds like, in jail or out of the picture when he was first born. He's been with foster parents, the presumptive adoptive parents at this time since then. So he's had 1 hour, mostly supervised visits now and then. So saying that the violence didn't occur in the presence of that particular child, when that presence has been during supervised visits, is not so compelling.
Your Honor, respectfully, that doesn't in any way make him an unfit parent, because if you
Oh, no, I mean, I'm not saying it does. I'm saying the violence and the aggression and the failure to address it could certainly factor into whether or not he's a fit parent. And then when your answer is, but that wasn't in front of this child, this is simply a defensive point that I'm making, which is, well, when would it have been? They've never had interactions outside of supervised visits. So it's not surprising that unless he's attacking the CFSA worker or the child in their presence, it would be pretty unlikely that the violence would take place in the presence of that child. It's definitely taken place in the presence of his other children by his own account, although that was in his account prompted by self-defense on behalf of his 15-year-old daughter.
Respectfully, Your Honor, these are all, most of them are hearsay. Most of them are hearsay. This social worker or any of these witnesses who testified at the adoption trial has witnessed any of this incident.
No, it's him telling, he's the declarant. He's the one who's reporting his own violence.
Well,
He's the one who says that I was in jail for domestic violence. I mean, this is according to the DBH report, which I don't understand to be challenged, and it's part of the magistrate judge's findings that he was in jail at the time of the removal because of a domestic violence incident, that he gets into fights and arguments pretty frequently. And during the course of this proceedings, he got into a fight with a woman because, by his account, he was defending his daughter. So these are party admissions. I mean, I don't know, there were no hearsay objections. There's no challenges to these facts on appeal. So I don't know what you mean to say they're hearsay. I mean, it's him providing the account, which seems fairly reliable to me.
well, Your Honor, respectfully, I have to disagree with the court's conclusion of those, simply because something happened in the past doesn't in any way make him to not a proper person to care for this child. Again,
I'm not saying it's
Yeah.
decisive. I'm just, don't those things don't they factor into a fitness finding though?
I'm sorry, Your Honor.
As I understand that might not be sufficient to find somebody unfit. There's a series of factors that the trial court, the magistrate, and the superior court considered. And I'm just saying, well, don't those factor into a fitness finding? Untreated anger management issues, repeated what appeared to be at least brushes with the law for assaultive behavior.
Well, I don't think Your Honor, magistrate just findings mentioned any of those. We came to the conclusion when he said that he's unfit, he's not a fit parent. Magistrate judge finding, basically, magistrate judge relied heavily on the evaluations, the psychological and psychiatric evaluation report, and some of the testimony by the social worker. I don't think he has, other than that, he has anything to conclude that my client is not a fit person to care for this child. So I would respectfully ask the court to reverse the lower court decision and send the case back to the trial court. Thank you, Your Honor, unless Your Honor has any other questions.
All right, thank you.
Thank you, Your Honor.
We'd like to thank both counsel for your briefs and arguments today, and the case is submitted. Thank you.
All rise.